May I say good evening, ladies and gentlemen, and welcome to another of our webinar series at Mercantile Barristers. Our topic of discussion this evening is how to avoid disputes and payment delays in construction contracts. Just by way of housekeeping, as we kick off this evening, the model of the webinar is that the first half is spent with me delivering the content that I have prepared for you. And of course, the second half will be open for Q&A, questions raised by you as you consider appropriate for me to deal with. So it's how to avoid disputes and payment delays in construction contracts. For those of you who are new to our webinars, my name is Samuel Okoronkwo. I started my professional career as a quantity surveyor. I then spent time qualifying as a project manager and becoming a project manager for a while. When I say for a while, for several years, and developing properties before heading back to the classroom to read law, qualify as a barrister, and now I practice as a specialist barrister in the built environment, of which, of course, construction is a significant part of. So I speak to you this evening with what I like to describe as a substantial degree of practical and professional experience in the industry in which all of us inhabit. That is it by way of introduction. So in trying to address the subject matter of this evening, there is a perspective that one has, say, from a QS's perspective. So when you look at construction contracts and the issues that arise in them, from a QS's perspective, I tend to see incidents of underestimated work packages on the part of the contractors. More often than not, there is a degree of claims consciousness on the part of contractors. And contractors will often retort that there is a degree of miserliness on behalf of the employer or the employer's QS. But that is not a fray that I intend to enter for the time being. There is often matters of inadequate budgeting, which would largely be on the employer's part, who's budgeted for the contract in hand. From a project manager's perspective, on critical analysis, you often encounter incidents of inadequate planning and programming of the sequence of construction activities. There is often inadequate resourcing of the project itself, and there are issues connected with coordination of the flow of information of the production and the management of release of construction drawings. And there are often under allowances with respect to contingencies, because of course, construction is not a finite act, and knowledge of that means that in your preparation, there ought to be a reasonable degree of contingencies provided for. And that is often an area that does not get adequate provision at the outset. From a practicing barrister's perspective, when one is instructed on construction disputes, more often than not, you can see aspects and elements of self-inflicted injury. Neither side in the dispute appears to have anticipated the likelihood of a dispute arising at all. Neither side eventually wins because they fight each other so tenaciously. And what do they finish up with is high cost of dispute resolution, that is either in adjudication, arbitration, or litigation. What are the consequences of these payment disputes and delays that arise? Of course, you suffer cash flow issues if you are the recipient of monies that you have planned for and it hasn't come. You suffer a shortflow in your cash flow. If you are the payer in the process, you may well find that you overspend. There is often a loss of profit Consequently, projects are often abandoned, contracts are abandoned, and contracts are abandoned. In the course of that, there are reputational, if you like, damage that is done to either or both sides. Future business opportunities are lost. Time is, of course, lost in the course of dispute resolution, and litigation ensues. Now, in trying to look at this critically, eventually it comes down to being able to manage one's internal management process with the contractual provisions. So whenever you pick up a set of contract documents, or indeed when you're negotiating any contract, absent contract documentation, ask yourself, what is this contract expecting me to do? And ask yourself, have I structured myself sufficiently to deliver that? Now, when you do align both, more often than not, you finish up with a successful project. When there is a total misalignment as to what your expectations of what you're supposed to do, and therefore how you have structured yourself, whether you're the employer, the architect, the project manager, the quantity surveyor, or the contractor, it's imperative to appreciate that you have to align what you intend to do with what you're contracting yourself to deliver. Because if you fail to do that, there is a misalignment, and that's, if you like, the genesis of disputes invariably. So I tend to advise clients that more often than not, the most valuable advice you can seek and obtain from your lawyer, be that your solicitor or indeed ultimately counsel, is how you avoid litigation. Now, I spend much of my time in court litigating, and I tend to look at clients and say, what steps have you taken to avoid litigation? Because more often than not, when you take steps to avoid litigation, you successfully avoid litigation. But when you have not paid any attention to it, you invariably finish in it. Now, to assist clients, because this is recurring and happening every time, we designed something at Mercantile Barristers called a dispute avoidance protocol. In trying to put that together a few years back, I wrote a piece that considered the 12 most recurrent items wherever you encounter a construction dispute. Now, I have a checklist, as I said, that one uses to advise clients and say, okay, in order to avoid these disputes, have you considered these things? Typically, some contracts start with a letter of intent. Client is, or the employer is, in a hurry to get to site and deliver the project quickly. Drawings have not been completed. Contract documents have not been produced. We'll give the contractor a letter of intent and let him make a start. Now, pause there and ask yourself, what's my contract sum? What specification do I expect this to be built to? But then again, we say we can start and make it up as we go. Now, when we are starting with an intent to make it up as we go, therein lies difficulties, because you have to take time to ensure, because at this point now you require, if you like, stronger management at the outset. Now, you ask yourself from the letter of intent, do we have a contract sum agreement? If, of course, you've tendered the contract and you received tenders in, you're more likely to have a fixed contract sum. But if you have not, it's open-ended. Query, am I prepared to deal with this? You should be making adequate provisions to be able to deal with how you conclude a final accounted contract, which has not started with a contract sum at the outset, because that's the benchmark to which your ultimate final account will be related to. You may well have a budget, and that is different from a commitment that both the employer and the contractor have agreed to. Do you have signed contract documents? If you do, you're further down the line. Even when you're further down the line, you still then have to manage that contract. Now, do you have a construction program agreement? Now, if you are the contractor, have you taken time to produce a construction program and put that to the employer, the architect, or the project manager and say, I want this agreed as the contract program? Now, more often than not, if you're the contractor administrator, you receive the contractor's program and you as it were, bank it. You put it in the in your cabinet. No, it isn't where it's supposed to be. If you receive a contractor's program, sit back, interrogate it. Ask yourself, is this practical? Is this deliverable? Now, if it isn't, you should be entitled to challenge it and ask the contractor questions. But if you have agreed it, that is where we're locked in. Now, the next thing is that during the course of the project, are you adopting a methodology that considers an estimated cost to completion at every stage of the project going down? Because if you have, you're more likely to arrive at a mutually agreeable final account. But if you have not, the likelihood is that there may be divergence, with one party expecting to final account at a particular figure and the other anticipating to final account at a figure that is at a considerable distance from that. Do you have a construction cash flow plan so that when interim valuations come, one has, if you like, almost a pre-estimate of what is likely to be in the interim valuation as against the program of work that is actually achieved? Do you have a specified date for contract completion? Or is time at large? Do you have a complete list of construction drawings that are issued? That is a dynamic document that is progressively updated whenever information is updated and moving forward. Now, do you have a construction information management mechanism? In other words, if the architect has produced what he considers to be a satisfactory set of working drawings, the contractor may well consider that he requires additional detailing in order to make it work. Now, does the contractor have a request for information mechanism that feeds into the architect in a manner that is pre-agreed, that if the architect receives the request for information, the architect say, okay, I'll have 48 hours to turn it around, or I have 7 days to turn it around. So the management of information flow, because ultimately information is the lifeblood of construction as much as cash flow is. So if you have a construction information management system that is pre-agreed, that is fantastic. If you're lacking one, you should have one. Now, do you have a standardized schedule of recording contract variations, seeing what was tendered as against what you're being asked to build? Is anyone taking time to estimate the cost implications of these, what I call departures from that which was intended, and the program impact of that at the same time? So for variations that arise, of course, there may be extra money to be spent. There may also be extra time to be incurred. Now, of course, some architect's instructions may well, if you like, remove things, in which case time is saved and money is saved, because there are deductions from what is tendered. Over and above that, the variations that are being priced, both in terms of money and time, is it getting the project administrator's sanction? Is it being signed off by the payer saying, okay, I understand these and I'm going to be able to pay for them or accept them? Now, if you've got these 11 steps that I've quickly run through in position, then you're in a tunnel to a successful final account within time. If you're not, then you can see in the progress of that the likelihood of difficulty arising. Now, I mentioned the dispute avoidance protocol and the 12-point plan, and I see recently in the news that, if you like, an employer as big as Network Rail is announcing that they have, in fact, started implementing a dispute avoidance process, and they're actually stepping forward to say that they're saving £1.2 billion by trying to eliminate disputes. Now, that is highly commendable. And I say that if it is good enough for such a sizable employer, it ought to be good enough for each and every one of you, irrespective of the size of contracts that you are engaged in on a daily basis. So it's highly commendable, and it is good to see that mentality is actually becoming more prevalent than not. So I tend to try and bring these things to life by referring to one or two examples that one encounters in practice in real terms. And my clerk, to who I commend, picks this one out as a good one. Now, what came in at the outset as part of the brief, and I'll read this, I've put it up there. Now, it says, "Dear Samuel, we're looking to get some advice regarding a project that has constantly gone downhill, both financially and contractually." Now, I've highlighted aspects of this brief in red because it ought to be striking a chord as to what you may or may not be encountering in the projects that you have. You said the key thing here is that the project has gone consistently downhill, both financially and contractually. But with this contractor said that they're undertaking the demolition and groundworks on a conversion project. As I'm sure with most cases that you deal with, he emphasizes it's not completely black and white, which is a fair admission. The project was started in the middle of last year. It was started under a modified JCT contract in which we had comments on and agreed changes via email, specifically relating to the design responsibility that we refused to take on. From the beginning of the project, there has been a continuous interchanging of management and financial persons and a lack of thought put into the pre-construction process. We were incredibly delayed on receiving the internal drainage design, which caused us to miss all of our key project dates set out at the beginning of the project. This was notified to them during the delayed process. Since this time, there has been an ongoing conversation about a lack of detail required to build a project. Furthermore, we have undertaken additional works following the revised drawings and have gone unpaid as the client is disputing its credibility with flimsy excuses from the contract. At this time, those variations are around several £100,000. We are now far past our initial agreed completion date, and we have no sight of finishing. There are continuous holdups with other subcontractors on the project, and their frustration are the same as ours. I'll be very interested in discussing this further with you. Now, on the right-hand side of your screen, I've picked out key aspects of this matter, of this case, sorry. Number one, the project has gone downhill financially and contractually, not good. Number two, there is ambiguity and uncertainty from the outset. It commenced middle of last year with the modified JCT. So standard forms contract has been amended. Design responsibility is now in question because one side is considering, of course, you have responsibility for that design, and they're saying, no, look at our emails of that date because we refused to take that responsibility. There's continuous interchange of management and financial personnel. In other words, project manager and QSs were changing. Therefore, the person you started discussing with at the beginning is no longer the person you were talking to in the middle. Neither are they the people that you're now talking to as you're approaching completion. There is a criticism of lack of thought in the pre-construction process. There is delayed receipt of drawings and lack of construction details. They've missed all project dates from the outset. Additional works following revised drawings that are variations. Clients refusing to pay the variations. On my own client's part, there's an allegation of flimsy contractual clauses being relied upon. Now, completion date, of course, contract completion dates long since passed. Time is now at large. Now, there are multiple contractor claims. Now, one sits back, when you get a brief such as this, you will see that there is an intersection of both time. Indeed, the 12 items that I have run through in the dispute avoidance protocol are largely all captured here. So what does one do? You go back to first principles and begin the process of analysis. And this is where I say that if you had set out with the dispute avoidance protocol at the outset, you will capture this at the first time. When things start going downhill at the outset, that is where you say, no, wait, stop. Here are the issues. We need to deal with them now before moving on. But what's happened in this case, of course, matters is cascaded down from the beginning, and now we're nearing completion and funds are not flowing. Now we're in difficulty, okay? And you now look at it, the example I gave of time, cost, and quality intersecting. So if you look at the graphic that I have, you have disputes that have time and cost, you have disputes that have time and quality, you have disputes that have cost and quality, but in the middle, you have the most intractable of disputes that have both elements of cost, time, and quality captured. Those are the most difficult to detangle. Of course, I wouldn't go into greater detail as to how we have set about resolving the difficulties in this case, because what you're now is at the foot of, if you like, entering the law courts to begin your dispute resolution. Now, the object of my webinar this evening is not to take you into the depths of the law, as is often the case with webinars given by barristers, because I know you are all practical people and it is late in the evening. Better for you to concentrate on the practical aspects of identifying these difficulties and then wanting to avoid them, rather than me telling you what the Supreme Court has decided on key cases, although there is a separate webinar that deals with matters of that sort. So you avoid these disputes and delays, as I said before, by controlling your own internal management processes to ensure that they are consistent and convergent with the contractual expectations. Now, it is therefore imperative that when you pick up any contract that you're going to manage, you want to sit back and ask yourself, what is my role in this? What is it that I'm expected to deliver? And how is it that I'm going to structure myself in order to deliver that? So I say the most valuable advice that you can get from your lawyer before is to avoid these disputes, and you try and avoid these disputes by, if you pick up our checklist and work through them one after the other. And if there is any aspect of it that you're not fully au fait with, then we can obviously assist you as necessary. So giving you real life examples of this, or actually taking this as elements, if you take time, for example, of the 12-point list, I show you a graphic where you have the contractual provisions at the top, and you're then going to look at where you have your completed project at the bottom. So for example, you've taken a project that is going to be 30 weeks from commencement to completion. If you completed the project on the 30th week, you have no dispute. You've met the contract program, no issues. Imagine where you've completed this project in 40 weeks. There will be issues with respect to extension of time, delay and disruption, and possibly liquidated and ascertained damages coming out on the other side. Now, imagine where you did not finish in 40 weeks, but you finished in 60 weeks instead. Now, if you look at that trajectory of dispute, the dispute prevalence or the propensity for you to finish off in formal dispute resolution will go from 0 to 100%. Now, in trying to manage time, you want to look at the construction program agreement for a start. You want to look at the specified date of completion. Then you want to look at your construction information management, because these are the key drivers of time. And that is where you are likely to encounter disputes that is time driven. So that is one illustration of the things to look for if time is going to become, as it were, of essence, and therefore cause you difficulties. Now, the next one is cost. If you're going to look at cost and payment disputes abound, taking the same graphic as well. So if you've tendered this contract for, say, £10 million, you are final accounting it for £10 million, everyone is happy. So 10 million, not a problem. Now, if you have tendered for 10 million and you're looking to final account for 15 million, you're tending towards dispute. If you're now going to final account for 20 million, you sure are in dispute mode. So what are you looking at? Start from your letter of intent, your contract sum agreement, your signed contract documents, your estimated cost to complete progress throughout the life of the project, your contract cash flow plan, your specified date of completing the contract and how that might have changed or what may have caused those, your schedule for recording contract variations, the cost and program implications of the same, the variations to the project as to whether or not they were approved before you start arriving at your final accounts. We make progress. If we are hitting issues that are quality driven, again, letter of intent, signed contract documents, construction program, complete list of construction drawings, contract information management, scheduling of your variations, and getting those approved. Again, from where you started, if you're roughly in line to the end, your propensity for a dispute is negligible. The further away you deviate from it, the greater the propensity for you to find yourself in formal dispute resolution. Now, what are the key issues that are apparent from here? The primary reasons that you encounter for your non-payment and your disputes is the presence of ambiguity. It could be that someone's literally failed in delivering their contractual obligation, but more often than not, you'd be surprised that often funds are withheld to exercise leverage by one party over another. What do I mean by that? If you're underpaid for what you're delivering, the payer may well want to compel you to achieve greater objectives, but maybe by doing a bit more, but then that will be where it may well be disingenuous. And that is balanced out often by contractors who front load their program and their construction contract in order to claim far more than they're entitled, in order to take out the profit from the projects at the outset. And when that is identified by the BDI QS, they may well choose to reverse it. So very important now to ensure that you align what you're trying to deliver and what is required of you, because that will eliminate ambiguity, clearly, hopefully avoid an utter failure. And then, of course, the exposure to leverage will also be eliminated at one and the same time. I say from practical experience that the cost of a dispute is often approximately 10 times the cost of preventing it. Now, when people sit back and wonder that you could actually take £5,000 professional advice at the outset and you would have just saved yourself £50,000 worth of litigation costs, then you wonder why more people are not doing it. But that is what they ought to be doing. Now, as counsel, of course, if I have to deal with this better as often as I have to do, I protect my clients in court. I see the pitfalls in the matter. I understand the realities of construction, that is not black and white, as we know, and then one can guide clients to anticipate where these problems will arise in their project, and then take timely steps, timely preventative steps to protect themselves. Again, most people only consult counsel when things have gone wrong. It's of course far more prudent to do so before the dispute erupts, because always, as we all know, a stitch in time saves 9 down the line. Okay, you have in your possession a checklist, but then it isn't a static document you keep and admire. You have to implement it. You have to actively, if you like, on a daily basis, ensure that your project team are well imbued, that here are the key items that's in our checklist, and we have to every day check them off, that we're ticking the boxes, because it is in mutual interest of both the contractor and the employer and the consultant's team that everyone is on the ball implementing the checklist and looking to avoid disputes. So our disputes avoidance protocol eliminates ambiguity in your contracts. It avoids confusion on variations and additional works, which, as we know, happens every day. You protect yourself from deviations in the programs. By that, you ensure that you are not the one deviating, but if someone else is deviating, that is not adversely impacting upon you. You clearly save considerable legal costs. You reduce and potentially avoid self-inflicted harm. You eliminate the risk of leverage that I have referred to before. And that is where I bring my presentation to you to a conclusion. And I've run through it rather rapidly, and I would have thought that I've used up about half of the time that is available to us. And the intention is to leave the floor open for you to have the flexibility to raise any questions that you may find, if you like, more relevant to the work that you are doing. So I thank you very much for listening, and I'm happy to hear what questions, if any, that you may have for me to address. And I hope you are all unmuted, or if you haven't been, you will shortly be unmuted so that you will have the freedom to speak as I have been speaking. So it's time for me to keep quiet and for you to speak.
Samuel?
Yes, please.
I'll ask a question. So you said earlier about you can avoid most of these. How do you kind of implement that in practice, in the sense of you're working in a way that you've done for a long time? How do you then make those changes so that you don't just crudely get caught with your pants down?
That's in a manner of speaking. Well, the difficulty, well, as I say, if you continue working how you have been working, then you shouldn't be surprised that the disputes continue to recur. And what we tend to do when clients come to us, more often people come to us when they're in difficulty, we solve that problem, then we turn around and say, but what's happening on your other projects? Have you done this? Have you done that? Have you done the other? So for example, one question is a client that we were dealing with on a matter that was on a full set of contract drawings. It transpired that they had 3 other projects that are on site on a letter of intent. So if they're on site on a letter of intent and you're powering away, what yardstick have you agreed with the employer for the payment for the work that you're doing? And indeed, what specification are you working to? Who has responsibility for that specification and the production of the drawings? Because what happens is that you are in receipt of a letter of intent from the employer saying, we intend to enter into a contract with you in due course, but for the time being, will you please commence? You have started probably demolishing and then clearing site, setting out. At this point, you have no more than general arrangement drawings. And the soil test results have now come out for the engineer to produce the foundation drawings. And you're progressing. The question from the employer's perspective is, what have you budgeted for this? The contractor is happy because as far as he's concerned, he believes he's going to be paid on day works. But eventually, a difficulty will arise if those day work rates have not been agreed. And indeed, where day work rates have been agreed, who is maintaining a record of the time that is being spent and then agreeing that the time spent is reasonable? Because when you say you have 20 men digging trenches, QS will come out, if you like, retrospectively and say, well, it was only 5 meters. How can you have 10 men digging that for 10 days? Then the issue arises then. And what you want to do at that point is introduce a mechanism where the records are mutually agreed or checked off, or there is a methodology for agreeing, if you like, a linear rate of, say, for example, mass concrete foundation that is X meters deep and Y meters wide. But the important thing is to realize that when this has not been quantified at the outset with the composite specification and possibly bills of quantities, that you then need to redouble your management effort at the outset to ensure that not only is there an agreed mechanism, but that there are adequate records to support that. And more to the point, when that work is done, don't leave it to the final account to bill for it or get paid for it. Because what happens is that, you know, you get on with the gusto of getting the work done, and the billing for what is being done is following retrospectively. Query, danger. If you get it in up front, at least if the employer is uncomfortable with the kind of figures that are coming, then they will be well informed to say, well, just hold on a minute. Let us try and address this slightly differently. Indeed, in one of the other instructions, they came to a standstill and they had to ask the contractor to stop work whilst the design is advanced. And when the design is advanced sufficiently for the contractor to return. Now, when they came to a debate on extension of time, the question is, what does the contractor get paid for the period that he was instructed to stop work? One school of thought was that he'd been asked to stop work. So you only did 5 weeks before we stopped you. You returned in week 20. Sorry. So it's just agreeing this thing. Sorry, there was an interruption there. So I wonder if I've over-answered your question or whether I've answered it sufficiently.
Yeah, no, that was great. There's one more. I don't want to kind of dominate here. There's one more, if I may, but it's kind of two-part. Obviously, we've got supply chain problems at the moment.
Big time.
We've got inflation issues on materials, even labor. Two scenarios. You've got those things playing on a site cost basis, all of that stuff playing in. You've got worker shortages. How does that work into a contract where the landscape's changed from when you price this, and unpicking when you're waiting for materials, how that affects the kind of whole production plan?
Fantastic question, actually, because that's very practical and matters that we have in hand presently. Your first port of call often is your fluctuations provisions within whichever contract you're working. And indeed, there's a question mark where, if you like, your supply has been impacted by what's happening in Ukraine, whether it is force majeure. The issue always, as one says, is that if you have a dispute avoidance protocol mindset, the earliest possible opportunity that you have, you should bring these difficulties to the employer's attention. Now, if you are tied into a lump sum fixed price contract for a protracted duration, the employer will say that you have taken the risk for this contract, for this duration, so it's not my problem, you deliver it. Clearly, there are exceptions that one can rely on, but most sensible employers would actually take the view that although this is the contractor's problem today, it will become my problem tomorrow if this project is not finished on time. Because let's face it, the likelihood is that the developer is funded to do the project. And we all know how banks will react if you're not meeting the delivery date, or they have step-in rights, which they can step in and take over the project. So wiser employers will want to, within reason, take reasonable steps to accommodate the contractor, of course, provided the contractor can demonstrate that they've taken all reasonable steps to avoid these supply chain issues and cost increases. And sometimes you may have to specify alternative materials or alternative components to achieve the same objectives. So I say that the advice there is to recognize it, report it at the earliest possible opportunity, and then try and work together where practical to deliver a result, but recognizing that ultimately someone has a contractual obligation to deliver, and that person must. Of course, it isn't written in stone that every project must be profitable, but of course, good contractors take steps to always ensure that they, at the very least, break even.
Thank you.
Okay.
On that similar kind of theme, contractually, contractors have been held to their fixed prices, even with remarkable inflationary costs on materials. Moving forward now, certainly up here, there are contractors who are reluctant, and understandably so, to give fixed prices on materials. Insulation has gone up 40% since January. They can't absorb it as a business. So the standard contracts don't really, as far as I can tell, deal with that very well. What kind of recommendations would you suggest putting in place where we're looking at entering contracts with no certainty on materials increases, and managing the contractors to not milk it?
Yes, I say that it's wise counsel to include a proviso within the contract which recognizes that risk, particularly those that are advised that are entering into contracts today, who cannot, with any degree of certainty, as you quite rightly picked out, inflation is one, timber is the other, and several other materials that are skyrocketing in prices. You just have to include a provision within the contract that this contract has been priced for these items at this rate. Should there be a substantial divergence, that the contractor should have an opening to return to the table, and that the employer will have to, as they say, not unreasonably decline to consider it. In other words, the contractor, a very prudent contractor, should include a provision to share the risk with the employer and not go headlong and say it's lump sum fixed price, you hold it there. Now, you have to include that. I think it is prudent to include that in these circumstances. If you're working on a contract already and you are now encountering this, it is still worthy of bringing the employer to the table and say, look, can we discuss this? And this is a very important point for TQSs, consultant quantity surveyors, who are advising their developer clients. And to say, look, ultimately, your contractor can go bankrupt on your contract, in which case you have yourself an almighty difficulty, or you can accommodate them knowing that hand-holding them to complete the project is safer for both sides than allowing it to go wrong. But at that point, what you ensure is that you're not, as you quite rightly put it, allowing the contractor to milk it. So if the contractor places an order for those, if you like, increased cost items, I will say, show me an open book, show me the order that is being placed. And indeed, the employer ought to, in certain circumstances, probably choose to pay direct to the supplier on the delivery and ensure that the delivery comes to your site, where, if you like, title passes to the employer on that occasion, rather than it stopping over with the contractor before passing to the employer. Because I now digress from construction law into insolvency law, because of course, if it has been paid for by the contractor and delivered to the contractor, and rather unfortunately, the contractor becomes insolvent in between taking that delivery and bringing it to your site, or indeed, whilst it is on your site, but yet to be installed, you may well find that title is likely to lie with the office holder, the liquidator, rather than you, the employer that has paid for it. So there are mechanisms. One looks at, I say that situations of the sort that you described, when they come across my desk in chambers, I describe them as being fact specific as to what steps that could be taken to ensure, because ultimately one has a singular vision of ensuring the successful delivery of the project in hand. So now the contractor is struggling to procure this material because, let's say, he quoted £1,000 for it and is now selling for 1,500. The employer may well choose to pay for it, to get it to site, to have it fitted, retain title to it, not record that cost increase, but then have that dealt with the final account stage. Okay? Does that strike a chord with you?
Samuel, I think an easier way to do it is to just have a greater frequency of the indexation clauses, or just relate it to the CPI index or something like that. Obviously, if a contract is longer than a year, typically they'll have indexation, variation of price clauses. If it's shorter than a year, or in the current economic climate where inflation is rampant as opposed to the historic 2%, you could just say, okay, as a compensation event or a variation, we'll actually agree to review that every quarter rather than annually.
I completely agree with you. Say that the indexation, as you say, is annual and it's within our purview of the usual 2%. But what is happening now is in excess of 10%.
Yeah. So what I'm saying is then, if you had an annual indexation clause from the client side, what you could ask for as a variation or a CE is for that to be reviewed on a quarterly basis 4 times a year rather than once a year.
That is a very positive suggestion. The one thing to note that I would add to that is that your annual indexation of inflation is general, but what you are on is project specific. So rather than apply the general to your specific, have that in mind, but look at some contracts provide for components that are imported more than those that are locally sourced. Plus again, even those that are locally sourced, one of the things is hitting, if you like, material suppliers now is the energy costs, because energy costs is going through the roof. Now, if you take that with your standard fluctuation indexation, you will be out by a mile. But the point is, the suggestion you make is a very positive one. That's one.
You'll have the specific indexations on contracts, and it's just a question of matching it to the appropriate one. Like if you're dealing with a road, the blacktop. On our contract, we've got 2 different indices, and they're prorated accordingly. But that's because we're on a National Highways framework contract, which is a 5-year contract. But if you weren't on one, there are a number of indices which you could specifically target, which are, should we say, more suited to the particular contract which you're on, as it were.
Indeed. Andy, are you a civil engineer?
No, commercial manager.
You're a commercial manager in a civil engineering company?
We just work with Adeo Global Consultants, so we work on the client side and the contractor side, so we see both sides of it, really.
Indeed. Okay. No, what you've made is a fantastic suggestion, one which I agree with, but then more regular reviews rather than the annual reviews. But then if you're in a 5-year contract, that is quite a challenge, because
I think, sorry.
Go ahead.
Yeah, some of the indexing, as you say, I feel it's a general. However, last year, at one point, steel was up to 300%. It came back down again. Insulation this year is 40%. So if index is applied across the board, it just doesn't work for very specific different inflationary rates that are also temporary across multiple different types of materials.
Hence the observation I was making earlier to Andy's proposition of, if you like, the annual indexation going across, because you want it to be project specific, and you want to have developed the relationship where the employer and the contractor both realize that it's in mutual interest to deliver this project. Contractor must not milk it, but the employer, you have to realize that ultimately your goal is to have this project delivered.
Yeah. Because what you mentioned about the fuel recently, you've got the situation of the red diesel levy, haven't you? Where they're, construction plant now, you can't use the red diesel unless you're using it for gritting lorries and stuff like that. You've got to pay the standard diesel price. So that's a change in the law which came in, I think 1st of April it was, from memory.
Exactly. And tell me how many contractors knew that when they were pricing? Very few. Very few.
Yeah.
Very few indeed. Yeah, it's quite...
Samuel, could I ask a question about variations?
Yes, please.
So I was going to when we're in a contract, partly through a project, and we have a dispute about a variation, we get a request to, as a subcontractor, we get given a variation and it isn't costed. And we go back to them and say, can we have that revised with the costing? Here's our costing, here's a substantiation. And they come back and say, no, sorry, our variation is in instructions. Can you continue with these specific works? We'll sort out the specific price of that variation at the final account. You need to proceed. And we push back on that and they say, no, you need to proceed in line with the contract. Would you have any advice on how we'd work with that at all?
I've recently advised on one. The difficulty you have for a start is that your obligation as a contractor is to progress duly and diligently with the works, and quite frankly, to obey all reasonable instructions given. However, you appreciate that if you ask the architect or indeed the project manager to attach his own cost estimate to the variation, it invariably doesn't come. You, the contractor, will say, this is what we estimate it will cost, and this is the program implication we estimate it will have. Now, when you get reluctance to the acknowledgement of that, I advise you always to ensure that in the next interim valuation, you include it. As you would appreciate, the employer will have to serve you with a pay less notice.
Samuel, sorry, just finish with that, but I just wanted to ask you.
Okay, so the employer will have to serve you with a pay well notice. What matters is that you have not only just, because of course what good contracts managers will do is try to avoid you exploiting the opportunity of a variation. One's approach would always be, and I'm putting my QS hat on here, to say that you want to always try to price the variation relative to the contract rates that have already been accepted, as much as practicable pro rata. To my mind, it would be unreasonable for a sensible contracts manager to decline to accept your variation when it is priced pro rata. The difficulty that some contractors encounter is when they price every variation based on their works. Do you see what I mean? So you have to exercise a degree of reason in when you are making your application, or when you're seeking that they agree that price. But for you, I will say that you should always keep a reasonable measure, and this is the point I make in part of the 12-point plan, of your own assessment of the value of the variations to their own assessment of the value of the variations. And when it comes to interim valuation, you have to insist that the variations that have been undertaken are paid for, even on an account basis, because otherwise they will have to serve you with a pay less notice. And then you have an opportunity in the course of that, not that one is encouraging it, you could adjudicate a matter in trying to resolve that in the interim. Never ever leave it to final account. The contract administrator will want you to leave it to final account. I say it is unhealthy both for the contract administrator and the contractor to leave it that far. So I think that is, if you like, my initial take on that. Sorry, Gustavo?
Yeah, Gustavo. I'm an architect and I deal with small and large projects. I got, quite a number of years in the profession. And I just wanted to ask you a question about small projects in this case. Okay. I think you've covered mainly sort of, standard or larger projects. And it's fantastic lecture, really. I'm thinking about maybe a new house, 150 to 100K works of contract, small kind of building. And I wonder whether you have a view when it comes to choosing the contract, to selecting the contract or recommending the form of contract, whether you think that a design and build or more elements of design and build would be advisable rather than less, or even an outright design and build type of contract over a traditional contract in this kind of volatile climate that we have, where there is so much uncertainty about so many issues, regarding procurement and, materials, labor, etc., as it's been touched on. inflation, etc. So I wonder if you have any views on those. Obviously, those tend to be less, I suppose, come to less, small projects. People don't tend to be too keen on going to disputes because the cost of the dispute would be a multiple of the cost of the project in the first place.
Project itself. Yeah,
but nevertheless, it's just something occurs to me as a concern.
It's a fair question. I tend to say often that the proper avoidance of a dispute starts with the choice of the form of contract. And as you have seen in the example that I used in my presentation, there were questions of design responsibility. In the ideal world, the best form of contract will be for there to be a design and build where the contractor has total responsibility and has no one to blame. The contractor designs it, the contractor builds it, and the contractor delivers it. The difficulty here is that the employer has specific views of what they want in their house. If you ask a contractor to design and build, they'll give you a box standard with magnolia everywhere and the standard products. And the employer may well say, no, I want a Georgian facade, or I want, if you like, a Tudor. Now, and that is where I tend to use an example. If you look at the automobile industry, the designer and the contractor are under one roof, working for one company. They design and build it. When a Mercedes is delivered to you, it is a Mercedes. You take it and you run with. Now, if you don't want it, if you want some specific special features in yours, you can include it in your order and it gets built for you. Construction is one fundamental large industry where design and construction is detached. And that is why we spend billions every year in resolving disputes. So the specific answer to your question is that as much as it is practicable, it often is preferable if the architect is under the same umbrella with the contractor. It may well start with the employer choosing an architect that shares their imagination, designing the type of building in outline that suits them, but then in the form of contract, agreeing to novate that architect to the contractor. Yeah. So the architect will, to a large extent, act as the in-house, if you like, anchor of the client, of the employer's expectation, whilst the contractor will bring in the buildability, and the contractor will from time to time impress upon the architect, why are we going for slate roofs that will cost 3 times more? Why don't we go for concrete tiles?
Yeah.
Hi,
now,
Samuel.
Indeed.
Sorry, can I?
Is that Leila?
Yes, it is. Hello. Thank you so much for your talk. It's been really informative, quite full on because I've had to really listen to so many of the points.
Okay.
But it's a very good talk. I just wanted to ask, a lot of the points that are covered, can they actually be resolved, thought through, and finalised at pre-construction stage to avoid any mishaps going forward? Because it sounds like a lot of these are issues that need to be thought through even before going, at pre-con stage.
I completely agree with you. And what I say is that the criticism of this industry of ours is that a lot less is invested pre rather than post construction. Now, it cannot entirely be eliminated, but it can substantially be reduced with the investment in time that is invested at the outset. So when you as an architect have an employer who wants to get to site, and just say, well, let's just pause and draw a breath here and just ensure that we have provided certain things. Now, the classic, actually, Leila, what comes through in your question is that the employer pushes the architect to get this project to site rapidly. The architect does so at her peril or his peril, as the case may be, because it is the architect that will be blamed for when the detailed information is not provided on time. But the way that these contracts work is that when the architect gets it wrong, the employer pays. So I have had to deal with a case where the contractor has brought, the contractor was running late. The contract administrator issued a termination of the contract. And then the employer took out proceedings against the employer. The employer took advice from their solicitors and decided that the failure was that of the contract administrator, aka architect. And then the employer then served a notice on the contract administrator saying, I'm told I'm going to lose this dispute, and if I lose, you're going to indemnify me because it was you that caused it. I'll just finish that by saying that what happened in that case, when the contract administrator sought to retain me to defend against the employer, I made a suggestion that you probably revert to the employer, persuade the employer to let me defend against the contractor on behalf of the employer, because if that was successful, you won't get, of course, to face any liability. And in the end, that was how that matter was resolved successfully on our part. But come back to it. The point that I'm driving home later, and you picked it all up in one, the greater the investment we make pre-contract, the more of the disputes that's likely to come out at the end that we eliminate. So they can be resolved. So it causes the architect, who is in essence the contract administrator, to think about the delivery, the construction process a lot more. Because you're designing these fantastic buildings, ultimately it has to be built. But have we made the provisions? And if we haven't, the dispute's coming down the line. And when that dispute begins to happen, the contractor will be attacking you. And if you're not standing your ground, you may well find that the employer is also attacking you. So for goodness sake, cut yourself slack there, take time, get it right before hitting the field.
Makes sense, thank you.
Good, good. So how are we doing for time? Do we have any more questions?
We have one from
Sorry.
So we have a question from Nicholas Warnes.
Nicholas.
Nicholas wants to know, do project teams, employers, contractors, architects, do they use your 12-point checklist as an agenda for a pre-start project planning meeting?
They ought to use it. Nicholas, if you can hear me, they ought to use it not just for a pre-start, but indeed at every project review meeting. Because the idea is to see the construction process as dynamic, is a continuum. It starts and it finishes. It starts pre-tender and it finishes with the final account. And if you have the benefit of the 12-point dispute avoidance protocol, you let it guide you throughout, and you will find that if you have any divergence at final account, it will be within tolerance. I suspect that's a short, sharp answer to the question. I wonder if Nicholas gets all of that.
There's one more question here from David from Rare Architects. It's a question on P&L issued by a client to an architect, which was delivered on an email but not received. Does such a notice need to be received to be issued or effective?
Sorry, I need to hear that question again to make sure that I understand it correctly.
So he says it's a question on PLN. PLN was issued by a client to an architect, which was delivered on an email. Oh, David is here. Do you want to ask your question,
Yeah,
David?
David, fire off, yeah, because I may have to ask you more questions.
Okay, it's a question about a pay less notice on a architect's fee, progress fee, which was issued on email apparently, but not received by us, we subsequent to the issue of the notice, actually the client started to pay portions of the owing fee but not the complete amount, and we're now probably ending in a dispute because they refused to pay the remainder of the fee owing. So I'm just wondering on the status of a notice under a contract like a PLN being issued on email, which wasn't received by us as architects.
As a general rule, electronic service is effective if there is a prior agreement between the parties that service by electronic means is acceptable. Absent such an agreement, question whether there is a sufficient course of dealing between the parties to imply that. Most likely not. In any event, the service will prima facie sound ineffective because there is an expression that it was never received.
Yeah.
And it might have been more prudent not only to serve it by electronic means, but also to put it in recorded delivery.
Yeah.
Because it has financial significance.
Yes.
And to ensure that it was in fact received. So if it is adjudged that the notice, the service of the notice was defective, it is therefore null and void. And payment, paying less when there was no effective notice to pay less, query repudiatory breach. And the employer had then to be served with appropriate notice that they must immediately make good the shortfall because the notice was defective. The notice, if in fact there was any, was defective. As such, they must make payment. Otherwise, that may well be a matter that can benefit from a short, sharp resolution.
Yes.
Okay, but then of course I express this opinion, hearing your perspective of it as different from the employers.
Yes.
Because as they say, every pancake fried has two sides to it.
Exactly.
Exactly. They will have a different opinion. But
yes,
on the basis of what you say, it seems to me
yes,
that the opinion I've expressed is a reasonable one.
Thank you very much.
It's a pleasure.
Many thanks.
It's a pleasure. So do we have any more questions?
No more questions, Samuel. Thank you.
Good. Now, ladies and gentlemen, it's been a pleasure addressing you this evening, and hopefully look forward to seeing you in our future webinars. Of course, some deal with other aspects of the built environment, from planning through to construction and dispute resolution. So thank you very much, and you all do have a good evening.
Thank you, Sam.
Okay, bye-bye now.
Thank you.
Bye.
Thank you. Bye-bye.
Bye.
Thank
Pleasure.
you.
Bye.